We're convened today in the matter of the State of Ohio versus Nancy Smith. That would be case number 94 CR0 45368, and as well State of Ohio versus Joseph Lee Allen, which is case number 94 CR0 45372. We're here pursuant to a prior hearing wherein the court vacated the sentence imposed upon each defendant, being a vacation of the judgment entry of conviction and sentence. The matter was appealed to the 9th District Court of Appeals. The 9th District Court of Appeals, in each case, ruled that the court had the authority to vacate the sentence and the judgment entry of conviction. When I first commenced my review of these matters, the object of the exercise was for the court to determine what would be an appropriate sentence. The court gave a presumption of validity to the original sentence, but thought that it would be prudent, if I were to consider a resentencing, to know as much about the case as did my predecessor when this sentence was imposed. So I decided to review the file. In that regard, I read the transcript of the trial, paying close attention to the testimony of the complaining witnesses in this case, but as well reviewing the balance of the testimony. In addition, I was able to review evidence that had been furnished to the defense during the course of the trial, which consisted of tape recordings of pretrial interviews with the complaining witnesses in the case. Before I commence that analysis, I want to make clear for the record that each detective, each law enforcement officer who investigated this case is a personal friend of mine, and for each of them I have the highest degree of respect. The matter was prosecuted by Lorain County Prosecutor's Office and by an assistant with whom I did battle for over 20 years. In reviewing his presentation of the case, it was clear to me that his motive was to do the best he could for the state of Ohio and for these witnesses who testified. He took advantage of every break he could get, as did the defense, as do all lawyers who are worthy to walk into a courtroom. I don't think in the course of my law practice I ever received a ruling from a court favorable to me that I failed to accept. And that is all this assistant prosecutor did. I think we should be mindful that this case was commenced in 1993 and it was tried in 1994. And it was done under the circumstances that existed at that time in terms of interviewing witnesses as best we could and the presentation of the case. The advantage that this court has is that I'm able to review the case with eyes that have had an additional 16 years of experience, both in trying cases such as this, and as well reviewing the applicable law that has applied over the years. In 1994, testimony of witnesses of tender age could be presented to a jury either by having the witness on the stand or by not having the witness on the stand under certain circumstances and under the authority of Evidence Rule 807. As a result of that, a great deal of the testimony presented consisted of out-of-court statements made by the child witnesses in this case, but presented by others. Evidence Rule 807 allowed other witnesses to testify to out-of-court statements by children if the trial court found that those out-of-court statements being brought to court carried with them a circumstantial guarantee of trustworthiness. Subsequently, however, in the case of Gaston versus Brigano, as cited in 2004 Westlaw 5349214. This case was decided at approximately the same time that this case was being tried, November 2004. And in Gaston, the Federal District Court for the Northern District, or for the Southern District of Ohio, ruled that essentially Evidence Rule 807 obviated the defendant's right to confront the witnesses against him. Given that ruling, this court cannot find that the testimony of witnesses beside the children as to the children's out-of-court statements would be admissible under any reasonable theory. Reviewing the statements, the court did not find that these statements would have been admissible under Evidence Rule 803, which would be statements made for the purpose of diagnosis and treatment, or Evidence Rule 804, which I believe is, if I can recall it, it should be the excited utterance exception. Hence that if Gaston is the law, and in this case has not been reversed, then that testimony should not have been admissible and would not be admissible in a retrial. In addition, the court, having spent countless hours listening to the interview tapes of the children, taking extensive notes, evaluating these interviews. The court would find upon review that the pretrial interviews, though the parties were doing their best, I'm talking capable social workers, capable and honest detectives, and parents, even though all doing their best to seek justice for these children, caused these interviews to be conducted in such a way that this court, at least, would find the interview process so suggestive that the children's in-court testimony would be inadmissible. The court also paid close attention to the in-court testimony of the witnesses and the manner in which it was presented, and I find that the elicitation of that testimony and the limitation on counsel with respect to their opportunity to prepare for cross-examination, even in light of the fact that counsel were not prepared for cross-examination, would have rendered the testimony not credible. In addition, I reviewed the disputes over the evidence that occurred during trial, especially the late delivery of the tapes of the pretrial interviews. The court finds that the tapes of these pretrial interviews should have been presented to the defense for transcription and cross-examination, for transcription, for the purpose of cross-examination, but for an even higher purpose. Each one of these pretrial statements could have been presented on behalf of the defense as exculpatory evidence. It would not have had to have been used simply to refresh a witness's recollection or to cross-examine a witness with respect to a prior statement. These pretrial interviews could have been presented as substantive evidence because they are part, not only because they are exculpatory, but because they are a part of the overall police report which a defendant may present in his own defense as substantive evidence. That is, evidence offered to prove a fact, not simply to refresh recollection or to confront a witness with a prior inconsistent statement. The court also reviewed other evidence that was furnished to the defense but not presented at trial, which included attendance records at the preschool that these children attended. Now, under the case of the city of Cleveland versus Triggerkowski, it's a 1999 case, pursuant to that case, the Supreme Court ruled that once it's been determined that the judgment entry of conviction and sentence is vacated, or if there is no final appealable order, the trial court can review any ruling that's been made up to that point. And Trevakowski was cited by the 9th District Court of Appeals in remanding this matter back, as well as State ex rel. Hansen versus Reed. Trevakowski was cited for that authority by the 9th District, as well as State ex rel. Hansen versus Reed, found at 63 Ohio State. Should be second. $597, $599. So that's what this court is going to do. And again, I don't believe that there was a human being in that courtroom in 1994 that was not there to do the best for his client, both defense counsel and counsel for the state of Ohio. Notwithstanding that, I have absolutely no confidence that these verdicts are correct. And therefore, I'm hoping I'm getting these cases right. In case number 9, in the case of State of Ohio versus Joseph Lee Allen, case number 94 CR 045372, and in the case of Nancy Lee Smith, and I believe that is case number 94 CR 045368.
Judge, she has 2 case numbers.
Didn't this go to trial under one case number, though?
I think both case numbers were to trial, Judge. I think also 93 CR.
All right, let me be,
4448.
thank you, Attorney Brad. Let me be overly cautious here, and I will recite all case numbers. I believe the State of Ohio versus Nancy Smith should be 93 CR 044489 and 94 CR 045368. State of Ohio versus Joseph Lee Allen should be 94 CR 045372 and 94 CR 044448. Absolutely no confidence that these verdicts are a correct statement. Pursuant to Criminal Rule 29C, the court will sua sponte. The jury having been discharged, enter a judgment of acquittal on behalf of the defendants Smith and the defendant Allen. In this matter, as an end, the defendants are each discharged and their bonds will be ordered released.
On behalf of the state, we object to the ruling of the court.
Thank you, Attorney Corey. The State of Ohio objections have been, we're in recess.
You all right? I don't
If you feel like talking to you, you can talk.
I guess what I can say, because we've talked before, is Mr. Allen's placed his trust in God all the way through this, and it was God that brought this to the final conclusion that should have been all along. Thanks.
Thank you. Well, you better do.
I'll get you under the before I can get out of here.
Done. It's done. Done. Done.
No, I think he is shot. Maybe I'll take a shot.
Right?
Is it going to be the next?
I get ready to talk.